Hello, hello. You guys want to go ahead and mute your mics and turn off your cameras? Mute your mics and turn off your cameras. Great. Well, thank you for joining us tonight for the Ohio Estate Planning Secrets Ins and Outs of Probate. I'm attorney Edward Littlejohn, the founding attorney and CEO at Littlejohn Law. And my goal today is to help you guys understand the probate process. And what I'm going to do is go over the probate process and give you an overview. I'm going to explain what probate is, when it happens, and why it happens. But before we begin, I have a short video that I want everybody to check out. All righty. I just wanted to share that with you guys. This year, I got nominated and accepted the award of an elite lawyer in the practice area of probate. And so it's really an honor to be able to share what I've learned with you guys over the past a little bit more than a decade. So, just a little bit about myself. Back in 2011, I started practicing law, and I quickly found estate planning and probate to be an area that came near and dear to my heart. You see, there were a lot of people in my family who needed assistance with estate planning, whether that be wills, trusts, healthcare, power of attorneys. And one of the things that I quickly learned is that people needed access to information to help them make well-informed decisions, information that would help their family avoid the headaches of transferring their assets from their loved ones when they pass away, or even planning to deal with their loved ones in the event that they passed away. And so, as I started studying and learning, I saw that probate was a very unique area because depending on the court, depending on the local rules, each court kind of handles it slightly different. And as a result, it makes it difficult for people who are kind of involved in the probate court process. And my team and I, we focus on making this as stress free as possible for you and your family because we know that dealing with the loss of a loved one is hard enough, right? You're dealing with the loss of your loved one, and then to have to deal with the probate court process on top of that, it's very difficult and burdensome. And so, like I said, tonight we're going to be talking about probate. I'm going to go about over what happens when someone passes away. We're going to go through why we need to probate, and I'm going to go ahead and jump in and get started now. Now, remember, if you have any questions, feel free to put them in the chat, or towards the end, you'll be able to open up your mic and ask your questions. So, the first thing I want to talk about is kind of an overview of what probate is. Now, in my opinion, probate is the legal mechanism that is used to transfer the assets of the deceased. So if I have the title to my car in my name and I want to give that car to my children, and I'm not here to sign the title because I passed away, that makes it a probate asset. And so any asset that's in my name at the time of my death constitutes a probate asset. And so probate is the legal process where we identify the assets, we identify the heirs, and then we transfer the assets to the heirs. Now, as a part of that process, there are creditors or other third parties that may want some sort of reimbursement or money from the estate. And as the probate process goes through, we have to notify those creditors and they have the right to make claim. So, we're going to talk a little bit more about that later on. So, when does probate actually happen? Well, When someone passes away, most of the time, people contact our office when they can't get access to something. So earlier this week, I was working with a client whose grandmother passed away. And as a result of her grandmother passing away, the bank account was frozen. And because they need access to the bank account, the family is now ready to probate the estate. But if they didn't need access to that bank account, they may not have probated the estate. Again, why does probate happen? It happens because people tend to need access to their loved one's assets, whether that's a bank account, whether they want to renew the home insurance, or even renew car insurance, or the tags on a car. That normally triggers some sort of probate uh, process. The next thing I want to talk about when it comes to probate, the approach that my team and I take is number one, we help you identify whether or not there's going to be a will. Okay. And that's kind of the start of this. Is there a will? Now, remember, a will is a legal document that the probate court follows to transfer the assets. So if I have a will and I leave my assets to my children, and the will specifically lays out, I leave it to my children, then the probate court will take all those probate assets and they'll transfer them to my children. However, if I don't have a will, then the probate court will transfer the assets under what's called intestate succession. Now, intestate succession is a legal proceeding where the probate court designates certain individuals to be your heirs or next of kin. Typically, it goes as follows. If you have children, it would go to your children. If you don't have children, it would go to your parents. If your parents have predeceased you, it may go to your siblings. If your siblings are gone, then if they have children, it would go to them. And it's a big, complicated analysis that ends with what the courts call the sixth consanguinity, right? And so it's a big analysis. So whenever my team and I are in a situation where we have to identify who the heirs are pursuant to the intestate succession laws, we end up making a family tree. And in that family tree, we identify, children, parents, grandparents, um, aunts and uncles, cousins, so that we can figure out who's supposed to legally inherit. Again, if you have a will, the will designate who is supposed to legally receive your assets. In the event that you don't have a will, then those assets are determined pursuant to the intestate succession laws here in Ohio. The next thing that we talk about when it comes to opening up an estate and kind of getting started, we look at what sort of assets the deceased have. And remember, those assets are the probate assets only. Now, a probate asset is an asset that requires the deceased signature to transfer. So if I have a home in my name only, that's a probate asset. If I have a car in my name only, that's a probate asset. And we need the probate court to transfer those assets legally. If I have a life insurance or maybe a 401k or a joint bank account, right? Those are considered non-probate assets because they transfer as a matter of law. So what do I mean by that? If I have a life insurance policy, we don't need the probate court's involvement to transfer the asset. All I need to do is give the insurance company a copy of the deceased death certificate, and then whoever the beneficiary is will be legally entitled to receive the funds. The next is same for a 401k. If there's a beneficiary, I provide the death certificate, and then whoever is the beneficiary is legally entitled to receive the funds. And if it's a joint bank account, those assets belong to both the deceased and the survivor. And so we don't need to do anything in order to access those funds because they are considered non-probate assets. Now, sometimes we see discord amongst family members. For example, we've worked with clients that have named one child out of four children to be a joint owner on the bank account. And then if mom or dad dies, the child whose name is on that bank account has taken control over that asset. And that's legal because it was a joint bank account and it's a non-probate asset. So, like I said, first we try to find out if there's a will that's going to dictate who is going to receive. And next, we identify the assets. What assets are we going to have to transfer through the probate process? The last thing that we do before we even get started with opening up the estate is we identify liability and expenses. For example, are there credit card debt? Is there any outstanding medical bill? Are there liens on a home or a mortgage on a home or a lien on a car? And so we will ask the next of kin if they're aware of any of those things, because that will help us decide when we're going to open up the estate. Now, a question that we often get is, hey, I've been identified as the executor of my mom's estate. Am I legally liable to pay all of her bills? The answer is no. You are not legally liable because you are the executor of your mom's or dad's or cousin's estate to pay their legal bills. However, once you open up the estate is legally responsible to pay the bills. So it doesn't mean that you have to take your money to pay the bills, but rather the assets that are in the estate have to be used to pay the bills. So what does this look like in real time? Well, a couple months ago, my team and I were working with a client whose father had passed away. The father had about $10,000 worth of credit card debt, but he had a home that was free and clear, no mortgage. He had a truck that was free and clear, no lien on it. And so as we administered his estate, the question came, how are we going to pay the $10,000 in credit card bills? Now, the family, they took the position, well, we don't want to sell the house to pay the debt, because that's what the probate court would do. They would order the individuals to sell the house or to take a mortgage out on the house, but to use the probate assets to pay the outstanding debt. In this particular situation, our client did not want to use any of the probate assets. He did not want to sell the home to pay the debt. He did not want to sell the vehicle, the truck, to pay the debt. So instead, we negotiated a lower amount and the client took his own money to satisfy the debt. Now, the probate court would not let us close the estate until this debt is satisfied. But again, he did not have to take his own money to pay the debt, but he chose to because he wanted to keep those assets free and clear. And so I just want to make sure that that's clear to everyone. You do not have to take your own money to pay the outstanding debts. So if there are credit card debts, if there are medical bills, you don't have to take your money to pay that debt. Now, once we get into the position where we're going to open up the estate, there is an order of payment. So the probate court, if we're going to open up an estate, the probate court is going to want to see a paid funeral bill. And so if you don't pay it today, but you pay it before the estate's closed, they're going to want to see that paid funeral bill. The other thing is the credit card debt or any unsecured debt. Under Ohio law, creditors have 6 months to make a claim against an estate. And so strategically, our team waits 6 months to open up an estate because under the law, two things have to happen for a claim to be properly made against an estate. Number one, somebody has to be appointed as the administrator or the executor of the estate. And number two, you have to receive notice of the claim. So what does that mean? If we wait 6 months before we appoint someone, then the creditors are going to lose the right to make a claim against the estate. Under Ohio law, the creditors can open up the estate on their own, but most of the time they refuse to do so because they're not sure what assets are in the estate. So this is another reason why it's very important for you to have an estate plan in place and make sure that you tell your children what assets that you have. See, another common misconception that we see are people think there's some big database that has all this information that says you own this car and this bank account and that bank account, this life insurance policy. When the reality is only you know what you own. And if you tell your children, then they know what you own. And so we find that it's very important for our clients to have that open dialogue with their children to let them know what assets that they have and how those assets are properly titled. Now, if you're unsure what assets you have and how they're properly titled, this is the perfect time to schedule a free estate planning review with my team. And my team will go over your assets, how they're titled, and what would happen today if you were to pass, so that can be crystal clear and you can know exactly what will happen. Okay, getting back to opening up the estate. So now we've looked for a will. We know if there's a will exists or doesn't exist. We've identified the assets that are there. We've identified the debts, if any, that are applied. The next step is bond. Now, what is bond? Bond is an insurance policy. And here's how it works. Bond is an insurance policy that is required by law to cover 2 times the liquid assets of the estate. So if someone passes away and they have $50,000 in their bank account, they would need an insurance policy, which we call bond, that would be $100,000. So this $100,000 policy would be in place in case the person, being the administrator or the executor, breached their fiduciary duties. And so what that means is that's a fancy way of saying if they took some assets that didn't belong to them, or they took these assets that properly belong to the estate. Now, in order to qualify for bond, you need to apply with an insurance company, and they will advise you, there's certain credit requirements. They have to do a background check on you to apply for bond. My team works hand in hand with you so that we can complete the necessary documents and apply for bond so that we can open up the estate. Now, if there's a piece of real estate, and let's say the home is worth $100,000 and then you have $50,000 in a bank account, then we don't have to worry about the real estate. And again, it's just 2 times the value of the liquid assets. Now, the next part is we're finally ready to open up the estate. And so what this looks like is step 1, we've identified the heirs, who's going to be receive notice, who may be entitled to receive under the will. And then we're going to prepare all the necessary legal documents to open up the estate. Now, let's say I were to pass away and I designated one of my team members at Little John Law to be the administrator of my estate. They would then notify my children, and my children would have to sign a waiver waiving their right to administer the estate because I had a will in place. Now, under Ohio law, there are certain people who have priority to open up an estate. If I have a will, whoever's nominated in the will as the executor has a right to open up my estate. If I was married, then my spouse could have the right to open up my estate, or my children could have the right to open up my estate. And like I said earlier, even creditors can open up the estate. Okay. Now, here's another common misconception that we see. Just because someone opens up an estate doesn't mean they're entitled to the assets. A couple years ago, I was working with a client whose best friend had passed away. Her best friend passed away. Her best friend did not have any family members, but she owned a home. And so the best friend wanted to open up the estate. And one of the things that we had to be crystal clear about was simply because you open up the estate does not entitle you to the home. We have to do our due diligence to try to find the next of kin, whether that's a cousin, an aunt or uncle, like a great cousin. We have to do the homework to figure this out so that we can give the assets to the proper person. Okay. Hopefully that makes sense. And you understand kind of the pre-opening up the estate and then the opening of the estate. So at that point, we would get everything submitted to the probate court, and the probate court would give us what's called a letter of authority. Now, this letter of authority is a magic key, in my opinion. Now, this magic key will allow you, as the administrator or the executor of the estate, to access any bank account, any IRA, any 401k, anything that was in the deceased name at the time of death. In fact, we've had clients who've had wills that identified them as executors, but other lawyers or law firms refuse to recognize it and honor the will because no official letter of authority was issued by the probate court. And until that letter of authority was issued by the probate court, no one has any legal right to act on behalf of the deceased. Now, if there are any questions based on that, feel free to put them in the chat. Again, any questions based on that, feel free to put them in the chat. All right. Seeing as there are none, I'm going to continue. So we've submitted everything to open up the estate. Now, one important thing to note is that the probate court has 90 days to appoint somebody as the administrator of the estate. Now, most of the time they do that way faster than the 90 days because all the people entitled to notice have waived their right to administer, which means they agree. And so the probate court will allow the person who applied to be the administrator or executor of the estate the right to be the executor of the estate, and they will issue the letter of authority. From there, 90 days after the appointment, the executor or administrator has to file an inventory and appraisal. Now, this inventory and appraisal is a list of all the assets that the deceased have. So if there are bank accounts, contents of homes, firearms. I had a one case one time, they identified the contents of a safety deposit box. So they said the contents of a safety deposit box, which was cash, was an estate asset. Now, part of the reason why they did that is right before the deceased had passed away, he had sold a car and he took the money from the sale of the car and put it in the safe with his wife. And because they put that money in the safe, they felt like it was a probate asset. Now, in that particular case, the battle was between the surviving spouse and her stepchildren. The stepchildren felt that they were legally entitled to the money that was in the estate because their dad died. But again, under Ohio law, there are certain elections and benefits that surviving spouses get because they are the surviving spouse. But again, that was an item that gets identified on the inventory. Now, once the inventory and appraisal gets submitted to the probate court, it is a list of all the assets and their values, okay? And so again, it's the list of all the assets and their values. From time to time, we see people say, you know what? There are assets that belong in the estate that aren't on the inventory and appraisal. And under law, the person who's complaining about that, they have the right to submit objections. That's right, they can submit objections to the inventory and appraisal, which means they do not agree. Now, if they submit those objections, the probate court will set the matter down for a hearing. Typically, the way it works is once the inventory and appraisal is filed, the probate court will set a hearing, but it's not a real hearing until someone files written objections to the assets that were on the inventory. Looks like we have a question here. And the question says, if I receive a home through a quit claim deed, do I need to go through probate to get access to the mortgage information? That's a great question. So if somebody receives a home through a quit claim deed, do they have to go through probate to get access to the mortgage? Assuming the property was transferred while the deceased was still alive, and you're looking to get access to the mortgage, yes, you have to go through the probate court because legally nobody is allowed to act on behalf of the deceased and get information about the deceased except for the executor or administrator of the estate. So to answer that question, yes, you have to be identified as the executor to be able to access the mortgage information. A couple months ago, my team and I were working on a case where myself was identified as the administrator of the estate, and we were working on it. And as we were working on it, the home had some property damage because a pipe burst, and we needed to make an insurance claim. Now, the only person they would give access to that mortgage information and the insurance information was myself as the administrator of the estate. The children couldn't get access to that information. Only I could because I was identified as the administrator of the estate. But great question. Seeing as we have another question, my mother's will was written 13 years ago in Rhode Island. Is it a valid will in Ohio? That's a great question. Without actually looking at the will, I'm going to default and say I don't know. The reason why I say that is because in Ohio, there are specific requirements for a will to be valid. Okay. So one of the things that to make a will valid is it has to be signed, it has to be witnessed by two disinterested parties. And as long as those requirements are met, then it would be a valid will in Ohio. Now, here's the thing. If you were going to open up an estate regarding the will that was written in another state, being Rhode Island, in Ohio, you would have to do a lost will proceedings. And a lost will proceedings is a process by which the probate court looks at a will that is not the original will and determines whether or not that will is a valid will here in Ohio. Now, in most of the instances, when we do the lost will proceedings, the people who sign the will, they witness the will, they either appear in court or they'll sign an affidavit acknowledging their signatures on the will to be accurate. And then the probate court will set the matter down for a hearing and then determine if the will is the valid will. Okay. All right. Looks like we have another question. If my father's will says I get nothing, my brother and I can't, can we contest it? Well, I mean, you would have to look at the will, right? You'd have to look at the will. And if it says that you get nothing, but it's not a valid will, then you may be able to contest it. The mere fact that it says you get nothing doesn't make it an invalid will. Some wills will have a clause in it that says if you contest the will, you're not entitled to anything. So you have to consider that as well. But in order to contest the will, you have to prove number one, like I said, that it is not the original will. So in probate, whenever we administer an estate and we submit a will, we have to submit the original will, like the one with the wet signatures. Okay. And number two, if you are trying to contest a will, it's not an easy task, right? It's a very high, difficult task. And most of the time, in order to contest the will, you have to be able to prove that the person who executed the will did not have the requisite mental capacity to execute the will. So it's not that you're upset that your brother is getting more money than you or somebody else is getting more money than you. You have to prove that your father did not have the requisite mental capacity to execute the will. Now, what does it mean by mental capacity to execute the will? The first thing we have to have is what the court calls testamentary capacity. And that means that your father would have to know who his heirs were. He would also have to know who or what his assets are. And last, he would want to know who those assets are to go to. So if your father's will identify all of his heirs, it also identifies all of the assets, then it's going to be presumed that this is a valid will. Okay. So it's a little bit more difficult than just contesting it. Maybe there's medical records out there that support the idea that this was not your father's intent. And if that's the case, then you would definitely want to get a consultation with my team so that they can kind of go through everything and see if this is something that we can help you out with. Okay. So moving on, once that inventory and appraisal is filed, the probate court, they have to approve it. Once it gets approved, as these are the assets that are in the estate, then we can start the plan for distribution. Now, if there were creditors who made claims against the estate, we have to figure out how we're going to satisfy those creditors. Most of the time, the plan for distribution focuses along the idea that your loved ones um, may be entitled to the asset. So if there's a piece of real estate and there's a will, then the will would dictate who gets that piece of real estate. It may say, I give it to all of my children, having 3 children, one third, one third, one third. And so the probate court will prepare everything to transfer the property so that there's a new deed that's executed that's in the third in each child's name. Sometimes when we get down to the distribution, the children will agree to sell all the assets, or the administrator or executor has the power through the will to sell all the assets and then just distribute funds, the money to the heirs. Now, most of the time, as long as everyone agrees, it's a streamlined kind of process if we're going to sell the contents. But if there's not an agreement, then the probate court will do whatever is the easiest. And most of the time, the easiest would just be to have an estate sale and give everyone money. If there's a piece of real estate, the easiest for the probate court to do would be to transfer the assets to the heirs. So a new deed would get executed in the name of the new heirs. The probate court is not inclined to try to negotiate an agreement between the heirs or anything like that. If there are or is an agreement, then the probate court most likely will honor it and follow it. But outside of that agreement, the probate court's going to do what's the easiest. And so when we talk about the distribution, we have to account for every asset that's in the estate account. Now, you might be wondering, well, what's an estate account? Remember that letter of authority that I was talking about earlier, that magic key. Once you have that magic key, you could go to a new bank and open up a bank account to put estate assets in it. That's right. If you were to sell the home and put liquid funds in the estate account, that is the account that we would need access to, and you would need access to, so that we could submit it to the probate court to do the final accounting to close out the estate. Now, what is the final accounting? The final accounting is an itemization of every single dollar that went into the estate account and every dollar that came out of the estate account. That includes probate filing fees, that includes legal fees, that includes any other expenses that were paid on behalf of the estate. If there were claims that were made and there were funds used, that goes on the accounting. Now, one of the things that you can't use the accounting for is your personal bills, right? Personal debts. Just because you're an executor, that does not give you the right to use estate funds to pay personal bills. You know, my team was working on a case a few weeks ago, and the administrator went to the casino and used estate funds to go to the casino, right? Again, you cannot use the estate funds to pay for things that do not belong to the estate. And so what ends up happening in those situations, which is why the probate court, they want itemized list, like dollar for dollar, all the way down to the penny. is that person, that heir, received less money because we treat it as an advancement. We treat it as an advancement against their estate. Okay. Once that accounting is submitted to the probate court looks for another waiver, right? Does everyone agree with the plan of distribution and how these assets are going to be distributed? And if everyone signs a waiver, then we can distribute the assets and start moving towards closing the estate. Okay. Now, that's probate in a nutshell. That was it from the beginning to the end. Now, in real life, it doesn't happen that fast. Normally, my team is very efficient and they're able to get estates closed within 9 to 12 months from the time that we open them. But we've seen some estates that have stayed open for 2 years or 3 years because there was some issue with an asset that either didn't make it on the inventory or there were newly discovered assets which delayed the administration of the estate. If you guys have any questions, feel free to put them in the link here in the chat. Any other questions about the probate court process, opening the estate, inventory, appraisals, distribution, or closing the estate? Looks like we got a couple. Nope. Any questions? Any more questions? Going once. Going twice. Sold. No more questions. What I'm going to do is I'm going to put the link for your free estate plan review here in the chat. Put the link in the chat, the free estate plan review. So what this is, if you're unsure how your assets would be transferred, then contact my team. My team will go over all of the assets that you have. They'll go over how they're titled. They'll go over who you want those assets to go to, and they'll be able to advise you of whether that plan is actually going to happen based on how the assets are listed. So if that's something you're interested in, feel free to reach out to my team. The other thing that's very important is that if you are unsure if you want your family to go through the probate process or if you want to avoid probate, then we recommend that you have a complimentary estate planning needs assessment with my team. Now, my team will go over, again, what assets you have, how those assets are going to be distributed, but we can also help you put together a plan to make sure that your assets avoid probate and the probate process altogether. One of the items that we use is a trust. Now, a trust is a legal tool that would take your assets that are considered probate assets and make them non-probate assets to transfer them so that your family can have a smooth transition of their assets. Now, last thing I want to say is keep in mind that if you have a modest estate of about $150,000, so $150,000, you are looking at anywhere from $12,000 to $18,000 in potential administration fees. The way it works is the administrator of the estate is entitled to a fee, and normally that is 4% of the first 100,000 and then 3% of the next 50,000. The attorney is also entitled to that same fee of 4% of the first 100,000 and 3% of the next 50,000. The probate court is entitled to an administrative fee that ranges anywhere from $250 to $350. And then there are other fees for recording, deeds, titles, different things like that. So you're looking at anywhere from, again, 12,000 up towards, we've seen the states where 18 or $20,000. Now, a trust is a lot more cost efficient. It ranges anywhere from $3,000 up towards 9 or 10,000 for the more complicated trusts. But those trusts can help your family avoid the probate process altogether. It'll allow your family to make a streamlined transfer of the assets, and it'll designate somebody to be the trustee, and that trustee can transfer your assets outside of probate court according to your trust. It makes everything happen very fast and smooth. So, the top three reasons why some of our clients love a trust is because number one, they can avoid the probate process. Number two, they've lived private lives, and so they get to keep all of their assets private. And number three, it allows them to quickly transfer their assets to their loved ones. And a bonus one is they get to keep their assets away from that stepdaughter, or not stepdaughter, their daughter-in-law or son-in-law, right? They get to keep their assets in their family's estate. Now, if you have any questions, feel free to reach out to my team. And remember, where there's a will, there's a way. Where there's no will, then there's probate. But the best plan is a trust plan. Have a good night, guys.